Hi, everyone. Welcome to ALEC TV. My name is Nino Marchese. I am the director of the Judiciary Task Force here at ALEC. And today we have a guest with us, and we're going to talk about some exciting reforms that Georgia's legislature is bringing in the tort and civil litigation space. Mark Behrens has been a friend of ALEC. He's been the former chair of the Civil Justice Task Force for many years, and he's currently the task force advisor to Judiciary. And so we wanted to bring him in today to talk a little bit about this new package that Governor Kemp has unveiled as part of a comprehensive court reform package. So the bills are SB 69 and SB 68. Both handle various issues in the civil justice space, many of which ALEC model policies have covered over the years. And so I want to bring some quotes in that people in Georgia have said about these packages. The governor has stated, quote, "Our legal environment is draining family bank accounts and hurting job creators of all sizes in nearly every industry in our state. The commissioner of Georgia, John King, has said that Georgia's legal climate amount to a hidden tax on families and small businesses, driving up costs and threatening our long-term future." And Georgia's Speaker of the House, John Behrens, has stated that the House is looking forward to working with Governor Kemp and stakeholders throughout Georgia to balance the scales of justice in our courtrooms and return stability to our insurance markets, all while respecting the rights of our citizens with legitimate claims to be made whole. So, Mark, what are your thoughts on this? Just the broad overview of this legislation and everything it's touching. What's your initial reaction to everything that they're doing down in Georgia?
Well, I strongly support what Governor Kemp has put together in his package, and we really appreciate his leadership and those in the legislature that have worked with him to craft this comprehensive civil justice reform. It's very important for Georgia, both from a jobs perspective, to continue Georgia's work to be one of the top states in the country for business, and also to help ordinary consumers with homeowner insurance rates, and auto insurance rates, which are very high in Georgia, in part because of their lawsuit abuse system.
Interesting. Now, these bills, they touch on a number of different issues. They deal with phantom damages, anchoring, seatbelt admissibility, attorney's fees, bifurcated trials, and third-party litigation financing. Now, I think one of the bills just primarily handles third-party litigation financing, so that seems to be a big component of this reform. Let's dive into that a little bit, and before we get into what the bill does, do you mind just helping kind of lay out the issue and explain exactly what is third-party litigation financing, why is it a problem, and why do you think Georgia's motivated to tackle it?
Well, what we've seen over the last decade is that billions of dollars are pouring in to invest in lawsuits in the United States. This money is coming in from large hedge funds, but also from foreign country wealth funds. Places like Saudi Arabia or even China are pouring billions of dollars into funding lawsuits in the United States, and also into funding the ads that go to create these lawsuits in the United States. There's a notable professor, Maya Steinitz, who spoke to 60 Minutes television show about a year ago. And she said that third-party litigation funding is fundamentally changing civil justice in the United States. The funders are helping decide which cases get brought, how they're litigated, when they settle, and for how much they settle. And all of this is being done without transparency. These funders are largely operating without any sort of licensing or regulations, and they're operating in secret. So the parties and the courts often today, when they go to settle a case, have no idea that there may be some very large institutional investor that's backing the plaintiff on the other side that really may have a hand in whether the case settles and what the settlement may be.
Yeah, there's a number of states that are looking at this practice. I know it's been a big top issue in the world of civil justice reform. But just breaking it down a little more structurally, how it actually works. People don't want to just fund litigation out of the kindness of their hearts. There seems to be somewhat of a investment scheme. People are looking for a return on investment like they would in the stock market. And my understanding, and I'd like to get your take on this, is that people are bankrolling litigation by the dozens of cases, if not more, all in the hopes that at least one of them lands a really, really large verdict or large settlement. But I think primarily a verdict is what these people are looking for. And that win justifies all the other litigation that they fund, that they're behind, and anybody else who comes in on that is going to get a return on their investment too. Do you think that's an accurate description of what's going on here and how that kind of plays out?
It is, Nino. So these billions of dollars that are pouring in are being used to both generate cases. A lot of the television advertisements you see on TV for mass tort lawsuits, that money is coming from these institutional investors or foreign sovereign wealth funds to create litigation. And then once that litigation is created, this money is also being used to fund the plaintiffs' firms to bring those cases forward. So it's being used by the plaintiffs' firms essentially as a loan, but it's one that is very attractive to the firms because it doesn't have to be paid back if the firms are not successful. So from the plaintiffs' firm standpoint, this is like playing with house money at a gambling table where they borrow money, and if they're successful in a lawsuit, they split the money with the funder, and if they're not successful, they don't pay the money back. So there's a tremendous, I like to use this analogy. If you were to go to a roulette wheel with your last $1,000, you're probably not going to bet that on a number because you can't afford to lose your own money. But now if I were to give you a $1,000 chip and say, bet this the way you want. And if you win, we'll split the proceeds. And if you lose, you don't have to pay me back. You're going to make the bet, right? Of course, because you only see upside in here, no cost. And so that's a psychology that is fueling this litigation. And from the funder's perspective, what they're doing now are buying what are called portfolios of cases. So they like to spread their risk too, because they're thinking about this, like if we're going to give you that chip to use on the roulette wheel, they don't want to be caught in a situation where they're betting all of their money on one spin. So what they do is they go to plaintiffs' firms, these large investors, and they go to a large plaintiff's firm, let's say with lots of cases over a particular pharmaceutical or pesticide, or it could be suing the federal government for cases arising out of Camp Lejeune. And these funders will go to the plaintiffs' firms and they'll say, we will give you $50 million or $100 million. I've even seen reports of some firms that are receiving $250 million, and they'll buy a percentage of every case that firm has. They'll go to the firm and say, we'll give you $100 million for 20% of all your Camp Lejeune cases, or, pick your mass tort. But that's how it's operating now, is that the funders like to spread their risk, and they will often say that they don't invest in frivolous lawsuits, that they're investors and they don't like to lose. Well, there's a difference between a frivolous case and a speculative case that may be frivolous in most cases. What they understand is that, like when you're drilling for oil wells, that you can hit 15 wells that all end up dry. If on the 16th well, you hit a gusher. And that's what they're looking for in the civil system. For example, if you look at talc-related lawsuits over ovarian cancer, one of the large manufacturers in that litigation won 95% of their cases. They won virtually every case in the United States that went to trial, but they lost one, and it was a verdict of over $2 billion to 20 female plaintiffs in the city of St. Louis. So if you look at that from a funder perspective, they may take a case where they know that they may lose 95% of the time if every once in a while they get a nuclear verdict, because that's enough to pay for the cases that they lose and get the large return on investment they're seeking. One of the large funders told 60 Minutes that they largely win about 90% of the time, and their return on investment, they're looking to double their money. So this is a very lucrative business for these people that are looking for a place to deploy their capital.
So a core component of all this, I would imagine, is the anonymity that comes with, funding so much litigation, trying to stay under the radar a little bit so you can invest, in multiple lawsuits. I think for that reason, states are starting to realize that one of the best ways to combat third-party litigation funding is to require registration for whoever's getting involved in a litigation, who's bankrolling it. That's certainly what Georgia has taken up. That's what's in this upcoming legislation, or I guess this current legislation that they've introduced, rather. Do you feel like the registration requirement is enough? Is that going to really solve the problem here by just getting people's names on a record?
Well, there's a couple of the registration is important. The state needs to know who's doing business there. But also, another core component of the legislation is to require disclosure. At a party's request, you could ask, is the other side being funded by somebody? And that's very important for both the litigants and for the court to know. Because one of the real policy concerns with third-party litigation funding is that it can put the one on the defense side, and I practice on the defense side, it can prolong litigation and make it more difficult to settle. There are cases that we've seen where funders have exercised a veto authority, what courts have characterized as reasonable settlements. So that's a very important thing from the perspective of courts and from defendants, is to know that when you enter into negotiations to settle a case, that you're going to be able to do that, and that the plaintiff is the person calling the shot on their case and not a wealthy investor in New York or London or some other financial market. The other risk with third-party litigation funding is that it can compromise the ethical obligations of the plaintiff's lawyer. So all lawyers have an ethical obligation to zealously represent their client's interests and to exercise independent judgment. That means that the lawyer has a fiduciary duty to always do what is in the client's best interest. But that can be compromised when there's a wealthy investor that may be calling the shot, either directly, in some cases that we've seen, or even directly, where they can threaten the plaintiff's attorney with whether they can get funding, additional funding in a particular case or funding in a future case if they don't play ball with the investors. And so that puts the lawyer in a pickle. And again, it's very important for the courts to understand where there may be compromises here of a lawyer's ethical duties, and to look at the funding agreements to make sure that there's no provisions in the agreement that crosses the line and violates the attorney's ethical obligations. Those would be provisions, for example, that would give the funder any control over settlement of the case.
Well, there definitely seems to be a lot of complex dynamics at play with this one issue, none of which seem to be rooted in justice. And it seems to be, somewhat of a abuse of the court system, quite frankly. You touched on this earlier. I touched on it a little bit too. Third-party litigation funding and nuclear verdicts kind of go hand in hand. Nuclear verdicts is somewhat of a phenomena that we've seen in recent years pop up, whereas, $1 million verdict, 20 years ago is now a $2 billion verdict today, depending on the state, the jury pool, circumstances, what the actual, damages were. That's kind of seems to be the cash prize and the motivation of pushing this third-party litigation funding. So tackling the nuclear verdict issue in and of itself, separate, seems to be a way to kind of combat the third-party litigation funding itself. This Georgia law seems to be doing exactly that through a practice of anti-anchoring. ALEC has an anti-anchoring model policy, the Anchors Away Act, and this prohibits the plaintiffs and the defense side from throwing out a number that the jury can latch onto to determine a verdict amount. How helpful do you think it is that they included that type of provision in this legislation to combat the third-party litigation funding issue at large?
Well, the ALEC Anchors Away model policy that you referenced in this Georgia legislation is very important for helping to curb really excessive verdicts that we're seeing with increasingly both the verdicts that we're seeing in the last decade in the United States are both increasing in frequency and more severe. So these what we call nuclear verdicts of $10 million or more are moving up, and they're happening more often. And one of the reasons for that is a tactic that the plaintiff's bar has developed that really is about, they understand human psychology and it's manipulating juries into awarding larger damages. Now, when we talk about compensating a plaintiff for injuries, there's two types of compensation. One is called economic loss, and that would be things that you can put a price tag on that are very objectively verifiable, like lost wages, where you can look at somebody's insurance return or their income tax returns or their W-2 stubs to know how much their earnings are, or medical expenses, where you can look at a bill, and we'll talk a little bit later perhaps about how those are being inflated. But those are very objective. When we get to the area of damages that are frequently called pain and suffering or non-economic damages, that becomes much more subjective, where if we interviewed 5 people off the street and said, I was in an injury, for example, and I can't use my arm any longer, what is the value of that from pain and suffering? How much pain and suffering should I get? You're likely to get very different answers from everybody that you talk to. And so in this area where there isn't a market, so to speak, and there's no way for people to have a standardized way of valuing those awards, plaintiffs' attorneys know that in that environment, that if they give the jury a number, even if it's a completely arbitrary number, jurors will latch onto that and use it as a measuring stick, for example, to determine the damages. A lot the way that real estate buyers might. For example, if I was to take you to Beverly Hills, California, and point to a large house and ask you, how much is that worth? You probably wouldn't be able to tell me if you don't have any expertise in that particular market. But if I told you now, well, a house down the street sold for X amount of dollars. Now you have a number that becomes your anchor, so to speak. And with that, you can compare it to the other house and decide, well, this house is a little bigger, a little newer. Therefore, I think it's worth a little bit more than the other one that you told me about. Plaintiffs' lawyers are doing the exact same kind of dynamic with jury awards. So they will go to a jury and they will ask, for example, please give my client $1 million a year for pain and suffering for the rest of their life because they've suffered an injury that may compromise their quality of life for the next 30 years. So that what we're seeing is in those requests come in, the juries are awarding $30 million more because they're taking with the lawyer that arbitrary number that the lawyer makes up, and they're grabbing onto that to say that is how we're going to value the award. And we may raise it up a little bit or we may raise it down a bit, but it is anchoring their decision. It is the standard in which they're basing. And
Right.
plaintiff lawyers have figured out that the more we ask for, the more we get. So 10 years ago, they were asking for $5 million and juries would give that to them. Then they started asking for $10 million and juries would give that to them. Now it's not unusual in tort cases to see plaintiffs' lawyers asking for tens of millions and even sometimes hundreds of millions of dollars for these subjective awards, and oftentimes they're getting it. And that is one of the principal drivers of the nuclear verdicts that we're seeing today. It is a form of inflation. It's in the industry, we call this social inflation, but it is a form of inflation, and it is a tort tax that is essentially baked into the cost of every good and service that we purchase. So next time you go buy homeowners insurance, part of that is going to reflect the cost of lawsuits baked into those claims. You go buy a car, it's going to be baked into the price of that car. So the higher our tort costs are, the more we can expect to pay for everything that we buy, all goods and services.
So anchoring is a component of this legislation. They also touch on phantom damages, seeking to eliminate those, seatbelt evidence admissibility. They restructure attorney's fees, backdated trials, obviously third-party litigation funding.
Let me touch on phantom damages, the truth in plaintiff's damages a little bit, because that one also may scratch heads of people that don't do this all the time. So, you know what? We've got 4 small children, and there's always somebody going to a pediatrician for something, a check. And you know that when you go to the doctor and you'll get the statement in the mail, it may say, for example, the pediatrician visit is $135. And then below that, it'll have discounts, negotiated group rate, write-offs, whatever it may be. And at the bottom is how much you, as the patient or the parent of a patient, actually owe. And it's usually much more reasonable, like $30 or $15. And that difference is what we call phantom damages. In Georgia and many places in the United States, the plaintiff lawyers can go to the jury and say the plaintiff's damages were the $135 sticker price for that service, when in reality, the patient is only paying the $35 or so that they actually have to pay after these negotiated discounts and write-offs and things like that. And so truth in damages is to say to the jury, let the jury understand that when we're talking about plaintiff's medical expenses, the out-of-pocket expense is what the plaintiff actually pays or owes, not the inflated sticker price that they never are going to be expected to pay.
Right. It's like getting a quote for, getting a new engine in your car, and turns out all they had to do was an oil change, and they're submitting the quote for the, $10,000, $20,000 job that never occurred. That's what's being factored in.
Yeah.
Multiple components of this legislation, all these things that you've touched on, seems to be a relatively comprehensive tort reform package. I guess I'm curious, what effect do you think it's going to have after the legislature passes it, if they pass it, on the general tort landscape, and even in potentially neighboring states? I know the Southeast is a litigation hotbed, for different plaintiffs' attorneys. So just looking beyond the bill being passed itself and just the general industry landscape, how do you think this is going to affect it?
I think if the bill passes in the form it's in now, that it's going to have a very significant factor in improving the litigation climate in Georgia. Georgia listed as the American Tort Reform Association puts out an annual list of what it calls judicial hellholes. These are places in the United States where you do not want to be sued, where you're not going to get a fair opportunity if you're a civil defendant, particularly a large corporate defendant that may be out of state. And Georgia was number 4 on that list. That's not a place you want to be, because it's not a place that people want to do business or employers want to locate. And so I think that there's a number of things to think about with this bill if it passes. One, Georgia will not be number 4 on the hellholes list anymore. It may not even be on the list anymore, because this is really strong, comprehensive legislation that the governor and his allies have put forward. Second of all, it will help reduce cost for ordinary Georgia consumers. This is not just a bill that's going to help big business or medium business. This is going to directly help Georgia consumers, ordinary citizens in the state. For example, in Florida, I live in Florida now, and Governor DeSantis took the reins and did something similar a couple of years ago, where homeowners insurance and auto rates were going through the roof in Florida. I've seen my home insurance double in the last 3 years in Florida. Some of it is because of hurricanes, but a lot of it is because of lawsuit abuse. And Governor DeSantis recognized this, and the Florida legislature stepped in and adopted some very significant legal reforms. And I just saw a press release out of the governor's office maybe a week or two ago, who said that rates are coming down in Florida, that tort reform has spurred competition in the marketplace. And that's good for consumers. That here in Florida, rather than seeing our rates go up and up, we're seeing the curve is bending and rates are actually coming down for many people. And that same kind of thing can happen in Georgia if this legislation passes. And the third thing that I think is important about this is it sends a message to employers around the country that Georgia is open for business and that Georgia wants their business, and Georgia is willing to do what is required to stand up to the wealthy personal injury bar, to put the interest of ordinary consumers and businesses first, to grow jobs and grow the economy in that state.
Well, hopefully Georgia moves forward with a successful legislative session for this bill. If, let's say, it does pass and this is motivating for legislators in other states to follow suit, is there anything in the package here that you think is particularly important that might not be in it, or any other advice that you have for legislators that may be interested and motivated to take these measures to implement in their own states?
Well, a very good question, Nino. And I think what we're seeing in the leadership a couple of years ago in Florida and now from Georgia, if it passes, and I hope it does, because I think, again, it's critical for growing the economy of the state, that Georgia is no longer one of the top 5 on the judicial hellholes list. But if we see insurance rates come down for homeowners or auto in Georgia, like we've seen in Florida, then I think we have another data point, and that may be very significant for other states, like Louisiana, for example, that is looking to try to encourage more competition in the insurance marketplace and lower costs for consumers there. In the past, we have seen in other states that have done comprehensive tort reform many years ago. West Virginia and Mississippi are 2 examples that it did help promote economic growth. And we've seen, again, more recently in Florida and Georgia, I think, with this package, if it passes like it is going to see significant new business in the state, significant benefits for ordinary consumers in terms of their prices on things like insurance, homeowners insurance, availability of affordable medical care. All of these things are going to improve the lives of ordinary folks in Georgia if this bill passes. And it sends an important signal to other states, particularly in the region, that this is a way to continue to attract jobs to your state and spur economic growth.
Great. Well, Mark, thanks for joining us today. I advise that you are Judiciary Task Force. Definitely advised me a little bit today on these issues, and hopefully our other members watching. Thank you for joining us.
Nina, and thank you to the ALEC members. I always appreciate working for them and how hard they work to help our country and make it better and stronger.
Absolutely.